Welcome to the deep dive.
Hey there.
You give us the sources, we dig in and pull out what you need to know. It's your shortcut to getting up to speed.
Yeah, getting right to the heart of it.
And today we are really zeroing in on, well, a pretty specific but important piece of patent law. It's Section 2126 from the MPEP, the Manual of Patent Examining Procedure, Chapter 2100 on patentability.
Right. And our mission basically is to figure out when a document that actually says patent on it can be used to, reject a patent application.
Exactly. The full title is Availability of a Document as a Patent for Purposes of Rejection Under 35 U.S.C. 102A or Pre-AIA 35 U.S.C. 102A B and D.
Okay, quite a mouthful.
It is, but the core question is super practical. When does a so-called patent, especially one from another country, actually count as prior art against your invention?
And the first big takeaway.
Well, just because it's labeled patent doesn't automatically make it usable.
Yeah.
It's not that simple. Okay, let's unpack that. So you find a document, maybe from Germany or Japan, it says patent right on top. That doesn't mean a U.S. examiner can just point to it and say, sorry, already exists.
Not necessarily, no. There's more to it. A really key factor, especially for using it under Section 102A or the Pre-AIA versions of 102A and B, is public accessibility.
Public accessibility, meaning?
Meaning it generally has to be available to the public somehow. The U.S. system cares about what people could have known. Was it out there?
So, like, published or available to look up someday.
Exactly. Those are the two main ways the MPEP mentions. Either it's formally published, kind of like we see with U.S. patent publications, or it's laid open for public inspection, maybe at the Foreign Patent Office itself.
Okay. So if a foreign patent office granted something but kept it totally secret, locked away.
Then under these specific sections, 102A and B, it generally wouldn't count as prior art, at least not until it becomes publicly available. Secrecy is kind of the opposite of prior art in this context.
Right. So this is where it gets interesting for you, the listener. If you're inventing something, finding out a patent exists somewhere else might not be an immediate roadblock.
Precisely. You have to ask how and when it became public. And the MPEP actually points to some court cases on this, like in Riekenstam and in Carlson.
What did they say?
They basically reinforce this idea.
Right.
If it was secret, it wasn't prior art under these rules until the public could access it. So the timing of that public access is crucial.
Now, you said generally and under these sections. That hints there might be exceptions or other rules?
Yes. There's a really important distinction when you look at the pre-AIA version of 35 U.S.C. Section 102D. That's one of the sections listed in the title.
Okay, Pre-AIA 102D. What's different there?
Well, unlike 102A and B, which focus on public knowledge, Pre-AIA 102D had a different trigger. It said a foreign patent could be prior art as of its grant date.
Even if it was secret, then?
Yes, even if it was still secret when it was granted.
Huh. That feels odd. A secret document blocking a U.S. invention.
It does seem counterintuitive compared to the public accessibility rule, right? But the logic there wasn't about what was known. It was about when the patent became legally enforceable in its home country. The grant date marks that enforceability.
So the legal status mattered more than public awareness for that specific rule.
For Pre-AIA 102D, yes. The enforceability date was the key. And there's a key case here, too, in Cathawala. The Federal Circuit confirmed that, yep, even a secret foreign patent could be prior art under that specific Pre-AIA section, based purely on its grant or enforceable date.
Wow. So for anyone dealing with patent applications filed before the American Invents Act really took full effect, this is a big deal.
It's a huge consideration. If your application falls under those older Pre-AIA rules, you might face prior art from a foreign patent that wasn't easy to find, simply because it was legally granted and enforceable before your relevant date.
It really shows how the law evolved and why knowing which set of rules applies to your application is so critical.
Absolutely. The effective filing date matters immensely.
Okay, so we've covered when a foreign patent might count based on accessibility or enforceability, depending on the law. Now, what about what in that patent document can be used? Is it just the claims? The legally defined invention?
That's another excellent point and another distinction the MPEP makes clear. When a document qualifies as a patent for prior art purposes, rather than just being treated as any other publication, the examiner isn't limited to just looking at the claims when they're making a rejection under Section 102.
Wait, really? So they can use stuff from the detailed description part even if it wasn't formally claimed in that foreign patent?
Exactly. The unclaimed disclosures within the specification The detailed write-up, the examples, the drawings, descriptions, all of that can potentially be used as prior art too.
Okay, that widens the net quite a bit.
It does. The idea is that the entire document, when designated as a patent under these rules, represents a certain level of disclosure about the invention.
Can you give an example of how that plays out?
Sure. The MPEP mentions a case, ex parte ovist. In that situation, there was a foreign patent with a pretty broad generic claim.
Okay.
But inside the specification, it describes several specific examples or species that fell under that broad claim. These specific examples weren't claimed themselves in the foreign patent,
Right.
but they were still used by the examiner to reject claims in a different U.S. application. The disclosure itself was enough.
So even if the legal protection of the foreign patent was narrow, the technical details inside could still block someone else later.
Precisely. And that Cathawala case we mentioned earlier supports this too. The court held that for Pre-AIA 102D, all the disclosed aspects of the invention in the foreign patent are relevant, claimed or not. Examiners could look at the whole thing.
Okay, so let's try to summarize this for you, the listener. When an examiner picks up a foreign document labeled patent, they need to check two things. First, when did it become usable as prior art? Was it when it became public, or under older rules, when it became enforceable? And second, what parts can they use? And the answer is potentially the entire disclosure, not just the specific legal claims.
That's a great summary. And the MPEP also notes that different countries have different standards for when something is considered publicly accessible, which adds another layer of complexity for examiners figuring this out.
It sounds like a real puzzle sometimes. Now, the outline also mentioned abandoned applications. How do they fit in? They aren't issued patents.
Right. Normally, unpublished, abandoned U.S. applications are kept confidential by the Patent Office.
Okay.
But there are ways they can become public. The rules, specifically 37 CFR 1.14A4, list some triggers. For instance, if an issued U.S. patent or a published U.S. application or a certain international publication specifically identifies an unpublished abandoned application, then that abandoned application can become publicly accessible. Basically, the later public document points back to the secret one, potentially opening it up.
So mentioning an old abandoned file in your new patent could make that old file public.
It could lead to it becoming available, yes. Another way is if you file a new application and claim the benefit of, or priority to, an earlier abandoned application. That act of claiming benefit can also make the abandoned application's file accessible upon written request.
So it's about transparency, making sure prior work doesn't stay hidden if it's relevant later on.
Exactly. It prevents things from being completely buried if they're connected to later public documents or claims.
This really paints a picture of how interconnected everything is. Domestic, foreign, published, unpublished, abandoned, granted. It all potentially links together.
It really does. And figuring out if a specific document, especially one called a patent, truly counts as prior art under U.S. law. Well, it involves looking beyond the label. You need to know when it became effective as prior art through public access or enforceability, and what within it can be used. And remembering that the rules can differ depending on the specific law section, especially pre-AIA versus post-AIA.
So the final thought for you, our listeners, maybe to just appreciate the layers here. When you think about prior art, especially involving international documents, realize it's not just about finding something with a similar title.
Right.
Understanding the nuances of when and how these documents become legally relevant, their accessibility, their enforceability, the scope of their disclosure gives you a much richer understanding of patentability. It really drives home why thorough prior art searching is so vital.
Thinking about how the timing and availability of patents worldwide could impact your own work or research area. It's complex, but crucial.
And remember, this deep dive is just one part of a larger educational series. We're going through the entire MPZP, chapter by chapter, section by section.
Yeah, and a huge thank you is due to Mike Shepard, our creative director. He's the one who organized this whole ambitious project, making the series happen.
Absolutely. And one final very important note for you listening. This summary, like all our deep dives, was put together using AI tools like ChatGPT and NotebookLM.
We strive for accuracy, but there could be errors or things missed.
Right. So please use this for general educational and informational purposes only. It is definitely not legal advice or a substitute for proper training.
For any authoritative guidance, you absolutely need to consult the official MPEP itself, talk to a qualified instructor, or get advice from a registered patent practitioner.
Couldn't agree more. Thanks for joining us for this deep dive into MPEP Section 2126.